I was halfway through fixing a broken fence post when two unfamiliar SUVs rolled slowly up my gravel driveway, tires crunching loud enough to announce trouble. They stopped just short of my property gate, doors swinging open like they owned the place. Out stepped three people wearing polo shirts with an HOA logo stitched across the chest, clipboards in hand, expressions already annoyed. The woman in front didn't bother greeting me. She pointed past the gate and said, "We're here for a compliance inspection. You denied access last time." That was my first clue this wasn't a misunderstanding, it was a power play. I calmly wiped my hands and asked who authorized them to enter my land. The man beside her scoffed and replied, "You're within the community boundaries. HOA officers don't need permission." That's when I felt that familiar mix of frustration and clarity. I'd heard rumors about this HOA, how they bullied neighbors, issued fines without warning, and treated private property like a suggestion. But I also knew something they didn't. My property wasn't part of their association. It never had been. I told them plainly, "You don't have access rights here. This property is not in your HOA." The woman's face tightened like I'd insulted her personally. She flipped open her clipboard and began reading violations out loud: unauthorized fencing, unapproved outbuildings, improper land use. Every word sounded rehearsed. I let her finish before responding. "None of that applies to me," I said. "You're standing on private land. You are trespassing." That word changed the air instantly. The man laughed, short and dismissive, and said, "Sir, we've governed this area for over 15 years. Everyone here answers to us." I asked if they had a map. They did. I asked if they had a deed. They didn't. That was when their confidence started to wobble. I walked to my truck and pulled out a worn folder I kept behind the seat, something my late father taught me to always have nearby. Inside were copies of my property deed, the original survey, and county boundary records. I held them up, not handing them over yet. "Before you take another step," I said, "you should know this land predates your HOA by decades." The woman crossed her arms and said, "Paper doesn't change reality." That comment told me everything. They weren't interested in facts, only authority. So I told them they had one chance to leave before I called the county. Instead of backing off, she stepped closer to the gate and said something that made my stomach drop. "If you continue to obstruct HOA enforcement, fines will be issued daily." That was the moment I realized this wasn't just about access, it was about intimidation. They expected me to fold, to apologize, to comply like everyone else. But I didn't. I unlocked the folder, pulled out one specific page, and told them I'd happily explain it, right after I called the county assessor and the sheriff's non-emergency line. The smiles vanished. And for the first time since they arrived, none of them spoke. The silence didn't last long. After a few tense seconds, the woman with the clipboard cleared her throat and snapped back into authority mode. "Go ahead and call whoever you want," she said. "Our legal department will handle it." She turned to the others and nodded like she'd just won something. They took photos, my fence, my shed, even my truck, standing just outside the gate but angling their phones like tourists collecting souvenirs. I told them again they were trespassing and needed to leave. Instead, the man smirked and said, "You'll be hearing from us." Then they piled back into their SUVs and drove off, leaving behind dust and a bad feeling in my gut. That bad feeling proved justified. 3 days later, I opened my mailbox to find a thick envelope stamped, "Final Notice." Inside were violation letters, itemized fines, and a warning that continued non-compliance may result in liens or legal action. They had fined me for fencing that existed before the HOA was founded, structures approved by the county decades ago, and failure to grant access to HOA officers. The total was already climbing into the thousands, with daily penalties added at the bottom in bold. What shocked me most wasn't the audacity, it was the assumption. They acted as if I were already guilty, already under their control. I called the number listed on the notice. After navigating a maze of extensions, I reached someone who introduced himself as the HOA's compliance manager. I explained, slowly and clearly, that my property was not part of their association. His response was chilling. "Our records show your parcel within our enforcement zone," he said. I asked what records. He hesitated, then said, "Internal boundary maps." I asked if those maps were filed with the county. Silence. Then he said, "That's not required." That was the moment I realized how sloppy and dangerous this HOA really was. I didn't argue further. Instead, I made my own calls. First to the county assessor, who pulled up my parcel number and confirmed, on a recorded line, that my land was not subject to any HOA. Then to the county planning office, which verified the same thing and emailed me official boundary documentation within an hour. Finally, I contacted the sheriff's office to report ongoing harassment and unlawful enforcement attempts. The deputy I spoke with asked one simple question: "Do they have any legal authority over your land?" When I said no, he replied, "Then they need to stop immediately." The next HOA notice arrived faster than I expected, this one escalating the matter, threatening a lien if payment wasn't received within 10 days. That was their fatal mistake. Filing or threatening a lien without jurisdiction isn't just unethical, it's illegal. I gathered every letter, every photo timestamp, every recording, and every county email into one clean packet. Then I sent a certified letter back to the HOA board with a subject line that said everything: "Notice of NO jurisdiction." I attached proof, cited statutes, and warned them to cease all contact. What I didn't know yet was that this letter wouldn't scare them, it would enrage them. I expected my certified letter to slow things down. Any reasonable board would have read the county documentation, realized their mistake, and quietly backed off. Instead, the HOA did the opposite. 2 weeks after they signed for my letter, a process server showed up at my gate with paperwork in hand. According to the notice, the HOA had formally recorded an intent to lien against my property for unpaid fines and continued obstruction of enforcement. They didn't just ignore the proof, I'd say they challenged it. And by doing so, they crossed from harassment into something much more serious. I drove straight to the county recorder's office the next morning. I wanted to see with my own eyes whether they'd actually gone through with it. The clerk typed in my parcel number, frowned, and turned her screen slightly so I could see. There it was, an attempted lien filing, flagged but not finalized. She looked at me and said, "This association doesn't have standing over your parcel." When I asked why it showed up at all, she shook her head. "They submitted it anyway." That one sentence hit harder than any fine notice. This HOA hadn't made a mistake, they'd gambled, hoping no one would stop them. The clerk called her supervisor, who confirmed the filing would be rejected but advised me to document everything. She also suggested I contact the county attorney's office, since filing false lien documents could carry penalties. I did exactly that. The assistant county attorney I spoke with asked me to email over my documents. 15 minutes later, she called back, her tone noticeably sharper. "You're not in their HOA," she said flatly. "They have no authority here." Then she added something that made my pulse spike: "If they attempt this again, it could be considered fraudulent." Meanwhile, the HOA wasn't backing down. I received an email blast addressed to affected homeowners, claiming that I was non-compliant and resisting lawful oversight. They didn't use my name, but everyone knew who it was about. Neighbors I'd never met started slowing down when they drove past, staring like I was some kind of problem resident. That's when it became clear, this was also about reputation. The HOA wanted to isolate me, paint me as difficult, and pressure me into giving up. What they didn't know was that every message they sent only strengthened my case. The turning point came when a sheriff's deputy stopped by my property, not because of me, but because of them. The HOA had called, claiming I was blocking enforcement officers and threatening legal action. I showed the deputy my documents, the rejected lien notice, and the county attorney's email. He read quietly, then looked up and said, "They shouldn't be contacting you at all." Before leaving, he asked if I wanted the interaction logged as ongoing harassment. I said yes. As his cruiser disappeared down the drive, I realized something had shifted. The HOA thought they were closing in, but in reality, they just invited the law into a fight they had no right to start. The HOA didn't retreat after the sheriff's visit. Instead, they did what organizations like that often do when cornered: they went public. A notice appeared on the community bulletin and website announcing a special board meeting to address jurisdictional disputes affecting neighborhood harmony. I knew exactly what that meant. They were going to talk about me, without me. But this time, I wasn't content to watch from a distance. The meeting was open under state law, and even though I wasn't an HOA member, I had every right to attend as the subject of their enforcement actions. The room was packed. Homeowners filled the chairs, whispering as the board members took their seats at the front table. The same woman with the clipboard sat in the center, now labeled HOA President. When the agenda reached the dispute, she spoke confidently about long-standing boundary understandings and internal maps that supposedly placed my property under HOA authority. She framed it as a stubborn homeowner refusing to cooperate. What she didn't expect was for me to stand up, introduce myself, and ask to be heard. The room went quiet in a way that felt electric. I laid everything out calmly. I explained that my land was never annexed, never subject to covenants, and never included in their recorded boundaries. I held up copies of the county assessor's confirmation, the planning office emails, and the rejected lien filing. Then I asked one simple question: can the board show a single county-recorded document proving jurisdiction over my parcel? The president hesitated, then said their attorney had advised them that internal documentation was sufficient. That's when murmurs turned into audible concern. Someone in the back actually said, "That doesn't sound right." Things unraveled quickly after that. A homeowner stood up and asked if those same internal maps had ever been used to fine anyone else. Another asked whether liens had been threatened without county confirmation. The board members started talking over one another, contradicting themselves. Finally, one of the quieter board members leaned into his microphone and said, "We may have overstepped." That sentence landed like a dropped plate. The president shot him a look, but the damage was done. The room had shifted, from skepticism toward me to suspicion toward them. The meeting ended abruptly, with the board announcing they would pause enforcement pending review. As people filed out, several neighbors stopped to apologize, saying they hadn't realized what was really happening. One even thanked me for speaking up, admitting they'd been fined before but were too afraid to push back. Walking out, I felt something close to relief, but also resolve. The HOA had been exposed, but not held accountable yet. And I knew from experience that pausing enforcement wasn't the same as admitting wrongdoing. The pause didn't last long. Less than a week after the meeting, I received a call from the county attorney's office asking if I was willing to provide a formal statement. Apparently, the rejected lien filing and the HOA's public admissions had raised enough red flags to trigger an official review. I met with them the following Monday, bringing every document I had: letters, emails, recordings, and screenshots of the HOA's website updates. The attorney flipped through the packet quietly, then looked up and said, "They never should have touched your property." Hearing that from a county official felt like the first real breath I'd taken in weeks. Within days, the county issued a written determination stating that my parcel was not part of the HOA, had never been annexed, and was not subject to any of its covenants or enforcement powers. That determination was sent directly to the HOA board with a cease and desist order requiring them to stop all contact with me immediately. It also required them to correct any public statements suggesting otherwise. What the letter didn't spell out in detail, but was very clear between the lines, was that any further action could expose individual board members to personal liability. Suddenly, the silence from the HOA became absolute. Then came the consequences. The county recorder formally noted the false lien attempt in the HOA's file, and the association was fined for submitting unauthorized enforcement documents. Their attorney withdrew shortly after, citing irreconcilable differences. At the next board meeting, this time sparsely attended, the president resigned. 2 other board members followed within a month. Word spread quickly through the neighborhood, and the tone shifted overnight. People stopped whispering when I drove by. Instead, they waved. A few even came by to ask how I stood my ground when the HOA came after me. The HOA sent one final letter. It wasn't an apology, more of a carefully worded retreat. It acknowledged the county's determination, confirmed my property was outside their jurisdiction, and stated that all fines and notices issued to me were void and unenforceable. They asked me to consider the matter closed. I did, but not before framing the county letter and filing everything away. Not out of spite, but out of principle. Because power like that only works when people don't question it. Standing on my land weeks later, I looked at the same gate where the HOA officers first tried to assert control. Nothing had changed physically, But everything had changed legally. They couldn't enter. They couldn't fine. They couldn't threaten. The words I'd said on day one echoed louder now than ever, not in the HOA. And this time, it wasn't just my voice saying it, it was the county, the law, and the record books. Final end: if you're dealing with an HOA that claims authority it doesn't have, remember this: ownership isn't about who shouts the loudest. It's about what's written, recorded, and proven. ***.